or not to?
The judgment has been satisfied.
We're partly paper file and partly online, so I do apologize for having to ask some questions that would be repetitive. And I'm sorry, you said, counsel, the judgment has been satisfied or not?
Yes, the judgment has been satisfied. I believe we did submit a paperwork to have that signed off on. I believe that was the end of last year. Fully understand if we need to resubmit that, we can do that again. But the judgment has been satisfied in full.
Okay. And so, Mr. Smith,
well, I'm only here today to set aside the default judgment that was set against me to begin with because they have the wrong person. I submitted evidence to the court that not only was I not living there at the time, it was the wrong race, wrong address, just wrong person altogether. I have reached out to this collection agency. I made calls and made them aware that I have submitted documentation, and I did. And I also made them aware that if need be, I will be willing to put in a police report of fraud. And all they told me was they'll see me in court. So I'm here today to address the wrongful, I guess, garnishment of my job while I was homeless, while COVID and seems as though they've been garnishing me wrongfully.
Okay. I do recall this. So, counsel, I'm looking at this proof of service that was filed by Thomas Smith.
Yes.
That states that Mr. Terrence Smith was personally served.
Correct.
He's white, 5 feet 10 inches tall, 185 pounds, and he has dark brown hair.
Correct.
That is not this Mr. Terrence Smith.
Other than the race, I do not know what he looks like in person since only head up. But other than the race, I mean, Your Honor, this case, the judgment was entered in 2020. So 4 years ago, we have had communication from Mr. Smith indicating this issue. He has failed to take the proper steps available to him. We have been in front of you before on objections to garnishment as well, which have been denied and found invalid, Your Honor, and he has still further not taken the further steps appropriate. I mean, pursuant to court rules, if he has failed to obtact, he has known about this and has failed.
Hold on, please. Mr. Smith, I can't have you interrupting because I cannot hear and we cannot record more than one at a time. So
yes, ma'am.
I'll have an opportunity to respond after that. I'm sorry, counsel, please proceed.
So he has been aware of this debt ever since the default has been entered and has had communication with our office. Pursuant to Rule 2.612, C2, he's not making the appropriate motion, and if he was making the appropriate motion, it is not made within a reasonable time, which is stated to be 1 year. There are not reasonable grounds. He has failed to take the appropriate remedies available to him by law to raise the issue. He just continues to file frivolous motions to say he was not served when, if that truly was the case, he has been aware of this issue for 4 years and has failed to properly pursue that defense.
Okay, so there's a couple things. Number one, what do your records show was the first time that Mr. Smith contacted your office?
October 8th of 2020. We received notification that we only contact him not via phone.
Okay.
May I speak, Your Honor?
Just a moment. I have a couple questions because I do recall this matter that it has been before the court previously, and counsel, who was, when you say in the city of Riverview, what is this, what is owed?
It was for an ambulance service, Your Honor. And the judgment was entered for the damages of $525, costs of $55.57, the statutory attorney fee. So the judgment total was $655.57, and then it accrued interest post-filing.
Okay.
So, but it has been satisfied in full.
Okay, and so, Mr. Smith, were you involved in something that would have required ambulance transportation?
No, ma'am. I believe during the time I was evicted at that time. And like I said, I have submitted documentation showing that I'm not 5'5" or a white male or living at that address. So even if it does say race-based, all information regarding me on that documentation is wrong altogether.
Just a moment. So, sir, you're telling this court that you've never...
No, when that first contact with me, I am not.
Sir, let me finish my question. You're telling this court that you've never been transported by ambulance?
Not during the time. I have been transported by the ambulance, but not at the time that they're stating here in court today that they're trying to garnish me for.
What city were you transported from, sir, by ambulance?
Canton.
That's the only time you've ever been transported by ambulance is in the city of Canton?
The Canton, as my remembrance will be Canton so far, Canton, Wayne and Westland, Detroit, and Livonia.
Your Honor, this underlying debt is from a service date of Christmas 2017.
Thank you. Do you remember that, sir?
I do not. So this are you stating that this service date of the ambulance was from 2017?
Correct.
No, I don't believe that was me at all. I don't believe I was. Like I said, there's too much information that is wrong on this documentation for it to state that it's me. And I also believe.
Hold on 1 moment. So here's what I'm going to state. All right, that somehow you were notified and appeared for these proceedings. How did that occur?
I proceeded for the proceedings that occurred. I think prior to this, I was aware. That's when I start proceeding and making myself appear. I believe they did reach out by phone call as some creditor. At the time, I just told creditors just don't call me. Don't call this phone number. That's just what I was telling creditors at the time, as in not my phone number at the time. But date back over what was going on 2017. Like I said, I don't believe they served me properly back then. She is true when she say that I have been in contact since last court date and to now, clarifying that I've submitted documentation and I will, if necessary, file police report and go the necessary route that is taken. I thought this was the necessary route. I did talk.
Mr. Smith, please, Mr. Smith, please just 1 moment.
Yep.
How did you become aware that there was a judgment against you?
I got a notice in the mail.
From
the post office. It went to the wrong address, then it came to my address.
Okay, so
address, then it came to my address. Then that's when I was been made aware, and that's when I actually started calling them and.
Excuse me. The wrong address, was that an address that you used to live at?
Yes.
Okay. So
I believe it.
Sir, let me just say this. There's been a satisfaction of judgment because the judgment's been satisfied. All
Okay.
right? The monies have all been paid. I would suggest, sir, that you contact an attorney if you believe that you did not owe this debt, that you were the wrong person, and that you want to recover the money. I cannot order that based upon what the court has before it right now. I'm not saying that you are or are not the person, okay?
I had a lawyer told me that this was.
Sir, please don't interrupt, please stop interrupting, okay?
Yeah.
I'm not saying that you are or are not the person that owed this money, okay? What I'm saying is, yes, I see the proof of service has the description of the individual that was served. That does not look like you. I will also note that Ms. Lomas is correct in the proper procedures that have to be brought in order to bring this matter before the court, and the proper procedures whereby to have a matter set aside. Now, the court is also aware that when the court ordered that the objections were not valid, that was, if I recall correctly, because Mr. Smith was stating that he was not the proper person and did not receive notice. And based upon that not being a valid reason to grant the objections, then the court had to deny that request and say that the objections were invalid. It is clear that the proof of service would indicate that Mr. Terrence Smith that was served and Mr. Terrence Smith that is present in court do not appear to be one and the same. However, it is also clear that there has been a number of years that there has been communication between the parties and documentation that's been exchanged. Mr. Smith, I strongly encourage you to contact an attorney so that it can be done in a proper fashion. I cannot give you legal advice. I cannot advocate for you.
Well, I have contacted a legal attorney, and they told me that this motion was the correct way to get the ball started. Then we'll have a hearing proceeding. When I came to court, I also came up when I filed this motion off the advice of a lawyer. Then I came to court just to make sure that this was the correct motion to file. The clerks there and my lawyer have advised me that this was the correct motion to file.
Okay, here's what I'm going to do. All right, what I'm going to do is I'm going to set this for an in-person hearing. I need all documentation from both plaintiff and Mr. Smith. I need all of it because, and sir, I need you to have an attorney represent me because there are certain legal arguments that need to be made that I don't know if you are aware of or not. If you are, then great. If not, then that's fine too. But sir, you need to bring proof of everywhere that you've lived, all of your mailing addresses, and counsel, it would be great if there was something regarding the ambulance service and any description of the patient that was transported Christmas of 2017.
Yes, Your Honor.
Okay, so then we will set this for Friday, September 6th at 10:30 a.m.
I'm sorry, what time, Your Honor?
10:30 a.m.
10:30. Thank you.
In person, yes.
Okie dokie. I may have another child custody hearing around the same time. Would I be able to call in prior to that just to double check the dates?
Sir, do you know the date of your?
I believe it is on the 6th or before the 6th.
On a Friday, it's a child support hearing?
Yeah.
Is it in front of a referee?
Yes.
Okay, my recollection when I practiced family law, I don't believe those are held on Fridays. Usually it was Monday through Thursday, but I could be wrong. So I'm going to state, sir, if that date does not work for you, you need to email in by Monday, August 12th, so that we can coordinate calendars if it's the same date and time.
Okay.
Okay, and you need to submit proof that that is the date and time of that hearing.
All right.
Okay?
Yep.
Would you be okay with that, counsel?
That's fine with me, Your Honor, yes.
Okay. All right, thank you. Have a good
Thank you,
day.
Your Honor.
All right,
All right,
thank you. Off the record. Okay, is that everything?
That's it.